I really, really, really can't wait to tell you about this case where Charter Cable, like the cable company Charter, is being sued by everyone.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
This is in the District of Colorado. This is a federal district court. And just go through this with me here for a moment. I'm just going to zoom in a little. We'll zoom back out, but go through this with me here for a second. We've got Warner Brothers, and then all of these corporations, all of these plaintiffs suing Charter Communications. And this is the recommendation of United States Magistrate Judge Michael E. Hegarty. A United States Magistrate Judge is not the judge for your case. They will issue a report and recommendations or something like that. So these are the recommendations of the Magistrate Judge Michael Hegarty. This action arises out of the alleged secondary infringement by the defendant of the plaintiff's copyrighted musical compositions and sound recordings. Plaintiffs allege defendant infringed on their copyrighted works by contributing to its subscribers, remember this is Charter, its subscribers' direct infringement, which they then call contributory infringement. So yes, okay, so what do they mean there? The subscriber's direct infringement was contributed to by Charter is the accusation, so that's called contributory infringement. And by profiting from subscribers' infringement while declining to stop or limit it, and they're calling that vicarious infringement. On a motion to dismiss the vicarious infringement claims, it seems like only. For the reasons that follow, this court respectfully recommends that the defendant's motion to dismiss be denied. So the vicarious infringement claim would be allowed to continue. And that is the recommendation. The judge is already telling you that he's going to deny the dismissal of the vicarious infringement claim, meaning the vicarious infringement claim stands along with the contributory infringement claim. But we're still at the beginning of the lawsuit. Statement of facts. Remember, we're on a motion to dismiss, so we are taking facts to be true if the facts have inferences that need to be read. If there's some ambiguity or something, it's going to be read in favor of the plaintiff, the non-moving party. Plaintiffs are record companies and music publishers that produce, manufacture, distribute, sell, license commercial sound recordings and musical compositions. Through substantial investments of money, time, and creative effort, plaintiffs and the recording artists and songwriters they represent, all of them, have developed and marketed the music and recordings listed on the attachments to the complaint, all of which have been registered with the Copyright Office. Collectively, plaintiffs own or control millions of musical compositions, which is their primary source of income. Charter is one of the largest internet service providers with 22 million subscribers nationwide. Defendant provides high-speed internet access for a subscription fee with a tiered pricing structure. Subscribers can purchase higher download speeds for higher monthly fees. In recent years, plaintiffs have become aware of persons infringing their copyrighted works through online, peer-to-peer, file-sharing programs such as BitTorrent. BitTorrent is a file-sharing protocol that allows users to transfer music and other files directly to one another over the internet. What makes BitTorrent unique from other file-sharing programs is that it facilitates much faster downloading by breaking each file into pieces, allowing users to download different pieces from different peers simultaneously. At the same time, the system allows users to begin disseminating the copyrighted content or whatever downloaded content. It doesn't have to be copyrighted content. There are legitimate uses for downloading. There are legitimate uses for BitTorrent. For disseminating the copyrighted content before the complete file has even been downloaded. This means that at any given time, each user connected to the internet can be both downloading and uploading different pieces of a file from and to multiple other users. Once a user has downloaded all the pieces, the file is automatically reassembled into its complete form. This is just an explanation of how BitTorrent works. The efficiencies gained from this type of file sharing have led to significant online piracy. A January 2011 report estimated that 11.4% of all internet traffic at the time involved the unauthorized distribution of copyrighted works through BitTorrent alone, at least according to the judge in this report. In a report from 2013, NetNames estimated that 99.97% of files distributed via BitTorrent infringe on copyrights. I don't understand why the other ones wouldn't either. I mean, we know what I do for a living, right? Further, in a well-publicized incident in 2015, millions of individual BitTorrent users downloaded an episode of Game of Thrones within just 24 hours of its airing. This is absolutely true. We know that Game of Thrones is the most popular pirated content in the history of pirated content, or at least it was. I don't know what might have overtaken it, if anything did yet. Let me know, too, because I want to know what shows are good. Plaintiffs' own copyrighted works have been distributed millions of times through BitTorrent, depriving plaintiff of untold millions of dollars in legitimate music sales. Defendant seeks to draw subscribers to its high-speed internet service, including subscribers who may wish to illegally distribute and download music through programs such as BitTorrent, by touting blazing fast speeds that allow you to download just about anything instantly, including up to 8 songs in 3 seconds. Subscribers in turn have utilized these speeds to pirate plaintiffs' works. For example, between 2012 and 2015, plaintiffs and their representatives identified hundreds of thousands of specific instances in which defendants' subscribers utilized peer-to-peer systems to distribute and copy plaintiff songs illegally. Tens of thousands of these subscribers were serial infringers, with some pirating hundreds of plaintiff songs over the course of several months. Defendant ignored the hundreds of thousands of statutory infringement notices. That's 100,000. Hundreds of thousands of infringement notices were ignored by defendant, allegedly, and according to the court here. Taking all facts, in light most favorable to the non-moving party, defendant ignored hundreds of thousands of infringement notices that plaintiffs and others submitted to it under penalty of perjury, each of which detailed specific acts of infringement committed by specific subscribers identified by their unique IP addresses. They go into the terms of service about how the defendant's terms of service expressly prohibit users from engaging in copyright infringement, and defendant has failed to address repeated infringement that occurs on its network. Defendant does not want to lose the revenue generated from these infringing subscribers by terminating their accounts, nor risk the possibility that account terminations would make its service less attractive to other existing or prospective users. Defendant does not want to devote the resources necessary to track repeat infringers and respond to infringement notices. Do you guys remember the Cox case that we reported on about a year and a half, 2 years ago, where Cox Communications, what was that, in Texas? I forget where it was, but they didn't implement a repeat infringer policy, so they lost their safe harbor. Safe harbor from what? From the copyright infringement of their users. They were not liable for facilitating the copyright infringement of their users because of a very clear law about them being in a safe harbor. Well, they didn't implement the law of the safe harbor, so they lost the safe harbor, and literally they got sued for, what was it, billions of dollars? And they ended up having to settle for many millions, if not like $1 billion or some dollars. I forget what the final amount was in there. Anybody remember? So defendants' refusal to terminate infringing users' accounts acts as a further draw to its service, as subscribers come to understand that they can download music and other files illegally over defendants' network without fear of being terminated. The specific infringing subscribers identified in plaintiff's notices knew that defendant would not terminate their accounts despite defendant's receipt of multiple notices identifying them as infringers, and they remained defendant subscribers to continue illegally downloading copyrighted works. Defendant's conduct encourages its customers to purchase even more bandwidth from the company and to continue using and paying subscription fees for defendant's services. When defendant subscribers use its network to obtain infringing copies of plaintiffs' works illegally, that activity undercuts the legitimate music market, depriving plaintiffs and those recording artists and songwriters whose works plaintiffs sell and license of the compensation to which they are entitled. Without such compensation, plaintiffs and their recording artists and songwriters have fewer resources available to invest in the further creation and distribution of high-quality music. So they go into the 12b-6 motion to dismiss standard. A complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. And that is the Ashcroft v. Iqbal, Bell Atlantic v. Twombly standard, those 2009 and 2007 cases from the Supreme Court. And those are very important jurisdictional cases, and that's why we always repeat that. Plausibility means that the plaintiff pled facts which allow the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. This is not a finding that they are liable. This is a finding that the case is ripe enough to proceed. Ripe is a bad word because that's another term of art that means something else. But it is correct here in the sense that the case is ripe at that point. But that's not, ripeness isn't the standard for a motion to dismiss. You could actually file a motion to dismiss if something was moot or not ripe. How about that? Twombly is a two-prong analysis. A court must identify the allegations in the complaint which are not entitled to the assumption of truth. That is, those allegations which are legal conclusions. They are assertions, merely conclusory. So those don't get a assumption of truth. And second, the court must consider the factual allegations to determine if they plausibly suggest an entitlement to relief. If there is a plausible claim for relief properly stated, the claim survives the motion to dismiss. I'm going to skip ahead a little bit here. The present motion seeks an order dismissing plaintiff's count 2 for vicarious copyright infringement. The 10th Circuit has determined that a defendant can be secondarily liable for another's copyright infringement under principles of vicarious and contributory liability. Vicarious liability attaches when the defendant has the right and ability to supervise the infringing activity and has a direct financial interest in such activities. One infringes vicariously by profiting from direct infringement while declining to exercise a right to stop or limit it. Let me highlight that. I'm going to use that the next time an opposing counsel tells me that my ISP defendants are liable. Defendant may be vicariously liable even when he or she is not aware of the infringing activity. Vicarious liability theory allows imposition of liability even if the defendant initially lacks knowledge of the infringement, but there must be a showing that someone directly infringed a copyright for vicarious liability to attach. Both contributory and vicarious infringements require someone to have directly infringed. So you can't just sue for vicarious liability and not have to prove the underlying copyright infringement. Here, defendants contend that plaintiffs fail to allege a causal connection between the alleged infringement and its profits, and thus fail to show a direct financial interest, and 2, that defendant maintained the right and ability to control infringement by its subscribers. The court will address both. Direct financial interest comes first. Citing cases from the 9th Circuit, defendant argues that plaintiff's allegations fail to demonstrate plaintiff derived direct financial benefits from any infringement. Specifically, defendant asserts that the alleged subscription fees defendant charges the infringing users constitute an indirect benefit because the infringing activity must be more than an added benefit to a subscription. It must be the attracting factor, the draw for its subscribers. Defendant contends that the only benefit it receives is a flat fee for the provision of internet services, which is insufficient to state a claim. According to defendant, at most, plaintiffs assert that subscribers are able to utilize their internet connection for illegal activity as an added benefit to the subscribers, not the draw. I would also add in there that they probably don't advertise, you can infringe on copyrights by coming to our service, or you can use BitTorrent to download the recording industry's music. I don't think that's how they advertise it. So, I mean, I get what they're saying. Let's continue. Plaintiffs counter that defendant misstates the financial benefit standard. Plaintiffs contend that the standard is permissive and imposes liability even for remote and unquantifiable benefits. Plaintiffs also argue that defendant misinterprets the Ellison case in that flat periodic fees can and do constitute direct financial benefits when the value of a defendant's service lies in providing access to infringing material. Again, though, they don't provide the access to infringing material, they provide access to the internet. The infringing material is then further through on the internet. I imagine this is going to be part of their arguments further on down the line since they've lost here. Plaintiffs conclude their allegations that Charter drew infringers to its service by touting specific features of its service that are attractive to copyright infringers and by adopting a policy of non-enforcement, and that these features motivated a subset of users to sign up for and remain with the company, together with allegations that Charter has a financial incentive not to terminate the accounts of infringing users, an allegation buttressed by the fact that Charter has declined to terminate users' accounts despite receiving repeated notices of specific users' infringement, are sufficiently plausible to state the direct financial interest element of a vicarious liability claim. Longest run-on sentence ever of Lawful Masses. I think Michael Hegarty just won it there. That was what was one sentence. I think this whole thing, somebody come with me here. Come with me now. This is one whole sentence, right? That whole thing is one sentence. Good job, Judge Hegarty. The court finds plaintiff's allegation taken as true at this early stage of the litigation plausibly states that defendant has a direct financial interest in the alleged infringing activity. Defendant is correct that the 10th Circuit has cited opinions from the 9th when addressing vicarious infringement claims. However, no case in the 10th Circuit has cited Perfect 10 v. Giga News, on which defendant primarily relies. The court, nevertheless, in Perfect 10, confirmed that a financial benefit exists where the availability of infringing material acts as a draw for customers, and the size of the draw relative to a defendant's overall business is immaterial. The court concluded that the essential aspect of the direct financial benefit inquiry is whether there is a causal relationship between the infringing activity and any financial benefit a defendant reaps, regardless of how substantial the benefit is in proportion to a defendant's overall profits. So it almost sounds like my argument from a minute ago that they aren't promoting infringing activity. Doesn't matter. It doesn't matter. Okay. The Perfect 10 court also noted in its analysis of Ellison, which has been cited by the 10th Circuit, emphasizing the difference between a defendant's receipt of financial benefits from infringement of the plaintiff's copyrighted works and the defendant's receipt of benefits from infringement in general. In Ellison, the 9th Circuit concluded, quote, the record lacks evidence that AOL, in that case, attracted or retained subscriptions because of the infringement or lost subscriptions because of AOL's eventual obstruction of the infringement. In other words, AOL's action upon its receipt of plaintiff's complaint of blocking access to the infringing material led the court to find that plaintiff failed to demonstrate the defendant received a direct financial benefit from the infringement alleged in that case. Likewise, in Perfect 10, the court concluded that Perfect 10 was required to provide evidence that customers were drawn to Giga News' services because of the infringing Perfect 10 material at issue. And there was no evidence indicating that anyone subscribed to Giga News because of infringing Perfect 10 material. While the 10th Circuit has cited Ellison and Fonovisa in setting forth the elements for secondary copyright infringement, the court has not yet engaged in an analysis of the direct financial benefit prong of such a claim. However, citing the Supreme Court's opinion in Grokster, wow, we're getting into the copyright history here for all of these infringement and like file sharing cases. Grokster was a file sharing case, for example. Perfect 10, wasn't one of those a thumbnail case, or was that the Perfect 10 v. Google? I forget. There was a couple Perfect 10 cases. Anyway, citing the Supreme Court's opinion in Grokster and the 9th Circuit's opinion in Ellison and Fonovisa, the District of Kansas determined that the financial benefit may be established by showing that users are attracted to a defendant's product because it enables infringement, and that use of the product for infringement financially benefits the defendants. So very simple. It exists where the availability of infringing material acts as a draw for customers. So how do you think that attorney or your law firm felt. The one copyright attorney in Kansas, I'm exaggerating, got the case. I mean, isn't that remarkable? Like, there was a copyright case in Kansas. I'm exaggerating. I'm sure there's copyright cases in Kansas all the time. In the Tomoleri court, the court addressed a motion for summary judgment and found that plaintiff failed to provide evidence that the alleged infringement was a draw for Zazzle.com users. This court, Michael Hegarty's court, here in Warner Brothers v. Charter, this court finds Tomoleri consistent with Perfect 10, Ellison, and Fonavisa, and concludes that plaintiffs have plausibly alleged, which just means that they alleged it, doesn't mean they win it yet, plausibly alleged the infringement of their musical compositions and sound recordings is a draw to defendants' subscribers. Taking the allegations as true, plaintiffs allege that defendant subscribers are motivated by company advertisements promoting defendants' high-speed service that enables subscribers to download 8 songs in 3 seconds. Defendant subscribers have used such a service to pirate plaintiffs' works, as evidenced by plaintiffs' identification between 2012 and 2015 of hundreds of thousands of instances in which plaintiff subscribers used its service to distribute plaintiff songs illegally. Despite notification of subscribers' infringement, defendants did nothing to stop it. Once defendant subscribers realized that defendant did not intend to stop or control the infringement, they would purchase more bandwidth and continue using defendant's service to infringe plaintiff's copyrighted works. And the greater the bandwidth used for pirating content, the more money that defendant made. These allegations are sufficient to demonstrate a causal relationship between the infringing activity alleged in this case and any financial benefit the defendant reaps in this case. Defendant contends that the opinion in UMG Recordings v. Grand Communications Network from February 28, 2018 in the Western District of Texas demonstrates plaintiff's allegations are insufficient to state a plausible direct financial benefit. This court disagrees. In Grande, the court found the allegation that the availability of plaintiff's music acted as a powerful draw for users of defendant's service was not sufficient, and noted that there are no allegations that defendant's actions in failing to adequately police their infringing subscribers is a draw to subscribers to purchase its services, so that they can use those services to infringe. Here, the plaintiffs do in fact allege that defendants' failure to stop or take other action in response to notices of infringement is a draw to current and prospective subscribers. The court finds the UMG Recordings opinion consistent with its conclusion that plaintiff's allegations taken as true are sufficient. Accordingly, the court respectfully recommends that Judge Jackson, the judge in this case, deny defendant's motion to dismiss plaintiff's vicarious liability claim based on a failure to state the direct financial benefit element of the claim. Okay, so the court moves on to the right and ability to supervise, and this is where I think Charter is probably in big trouble, if this is true. If this is actually true and those plaintiffs can prove all of this, which they wouldn't really have done this if they didn't think they could, then I think Charter's in real trouble here. Let's check. Defendant also seeks dismissal of plaintiff's vicarious infringement claim, asserting plaintiffs fail to plausibly allege defendant exercises any practical ability to control the online activity of the allegedly infringing subscribers here. Again, the Supreme Court has determined that a claim for vicarious infringement allows imposition of liability when the defendant profits directly from the infringement and has a right or ability to supervise the direct infringer, even if the defendant initially lacks knowledge of the infringement. That right and ability to supervise may be found even when a defendant is not aware of the infringing activity. The parties cite Perfect 10 v. Amazon for the proposition that a defendant exercises control over a direct infringer when he has both a legal right to stop or limit the directly infringing conduct as well as the practical ability to do so. Back to Grande Communications, which is cited by both parties, that case also cites Amazon for the same proposition. Like the plaintiffs here, UMG Recordings and the other plaintiffs in that case are a collection of record companies that produce and distribute commercial sound recordings in the US, and like defendant here, Grande Communications is an internet service provider that provides internet access to subscribers in portions of Texas. The court addressed Grande Communications' motion to dismiss the vicarious infringement claims, and, as set forth above, found that plaintiffs failed to allege plausible facts supporting the direct financial benefit element of the claims. However, before coming to that conclusion, the UMG Recordings Court addressed the same arguments defendant proffers here, based on the right and ability to supervise element. Quote, Grande asserts that because it cannot block access to the peer-to-peer software used to infringe on the copyrights, it cannot stop or limit the infringing conduct taking place by its subscribers. Additionally, Grande argues that even if it terminates subscribers, such action will only indirectly affect the infringing conduct, as internet access is ubiquitous and the subscribers can simply obtain the service from another ISP. The court disagrees. Grande can stop or limit the infringing conduct by terminating the subscriber's internet access. This is clearly sufficient to state a claim on the first element of vicarious liability. End quote. In fact, in BMG Rights Management, the court found that defendant, another internet service provider, had the contractual right to condition the availability of its access to users who do not use the service to violate copyrights. If users listen when Cox exercises that power, infringement stops. If users do not and Cox terminates them, that also stops or limits the infringement. The court also determined that the defendant had the practical ability to stop or limit infringement. There cannot be any serious dispute that internet service is an essential component of the infringing activity alleged, file sharing programs, etc. It is therefore a reasonable inference that the result of an ISP exercising its ability to suspend or terminate an account stops or limits the infringement. Once again, Michael Hegarty says that he will find those cases instructive as applied to this case and concludes that plaintiff plausibly alleges that defendant has both the legal right to stop or limit the directly infringing conduct as well as the practical ability to do so. There are terms of service they could use to cite that, and there are hundreds of thousands of notices of infringement as we've seen above. So he denies the vicarious liability dismissal. Why in the world, why might I think that they're in hot water? Even if they had won that dismissal, that was just the vicarious liability count, and there's also a contributory liability count that doesn't seem to be dismissed. So they're in pretty hot water. This is likely going to go the same way as the Cox case, and Charter's likely going to get hit with, I'm guessing a multi-billion-dollar judgment or settlement, I mean, because the judgment could be even higher. It could be one of those absurd cases. I don't know if I can remember it off the top of my head, but there was a case where literally the absurdity of the number was cited by the judge as a reason why the plaintiff cannot sustain a request for damages at that level. It's not just a multiplier of the number of alleged infringements times the maximum statutory damages. There is a number where it can reach too high. I think it was in the trillions of dollars. It was more than the gross domestic product or gross world product of the entire world, basically. So what do you think of that? Let us know your thoughts in the comments below. I think Charter is going to suffer a multi-billion-dollar settlement. I think that's what we just read. I think that's what's going to happen. I'm glad that I'm reading it and I'm not the one suffering the multi-billion-dollar settlement. So terminate your infringing subscribers when you receive notices, ISPs. That's actually important. 3 strikes and you're out, I think, is the way it works. Talk to your attorneys. Don't talk to me. Unless you want me to be your attorney, then you can talk to me. Yeah, not 12, Cox.
What happens in cases when the ISP is like the only ISP in the area and has to deal with the city where they're basically not allowed to terminate service for they don't have the option to actually terminate?
I mean, if I was a defense attorney in one of these cases, I would definitely cite that as well. Your Honor, I can't terminate this person. We're the only ISP in the area, and we are under orders, yada, yada, yada. And then I would totally throw that other entity under the bus. Like, no, they're the ones who are responsible. They told us to do it. Sue the city. I've not necessarily. Does such a thing exist where you're not allowed to terminate people even for misbehavior?
I don't know if it would count for misbehavior. I would imagine at some point they have to be allowed to terminate service, but there are some pretty harsh restrictions in cases where it goes to apartment buildings. And that's like the only provider available. Like there's literally no. I guess you could get dial-up, but there's no other. Other
well, I don't. I mean, I'm assuming that they mean to terminate the one subscriber that's infringing in the apartment building and not the whole apartment building. However, it's not like I've never had a client who was representing himself as an apartment building owner, and he basically bought like one internet connection under his name, like personally, and then he feeds that to all of his apartment building tenants. I'm sure that that's not quite legal either, but that's a contract dispute, not a crime. They're getting serious about those terminating infringer things, so you might find yourself terminated if you decide to infringe and don't heed the first warning, or however that works for your ISP. So be careful, because even Charter is having to do this now. I wouldn't know. I don't commit copyright infringement. I don't want that to be a headline. Your favorite copyright attorney sued for copyright is something I so seriously don't want to ever receive that I literally do not pirate anything. I'm not like I would admit it to you, but I'm going to go on the record and say, no, I actually don't affirmatively. I affirmatively do not pirate anything because I don't want to be that guy. I don't want to be that headline.
And I'll say the same thing. Since I started watching your videos, not even since I started being involved, but I just don't pirate things anymore. I buy everything now. Good.
And here's the thing, though, not to get into politics, but I do believe that a healthy society should be giving all of its workers a living wage, like requiring anyone who works to be working for what society establishes as a living wage, so that you can have the money to go buy your material instead of having to pirate it. Like, as society descends further and further into poverty, I bet you piracy goes up. Let's put it that way. I thought it might be funny to read all of these names. So just bear with me for like the 1 minute or 60 seconds it's going to take me to read through these. The plaintiffs in this case are Warner Brothers Records, Atlantic Recording, Bad Boy Records, Elektra Entertainment, Fueled by Ramen LLC, None Such Records, Roadrunner Records, WEA International, Warner Chappell Music, Warner Tamerlane Publishing, Warner WB Music, WBM Music, I don't even know what that is, Unichapel Music, Right Song Music, Cotillion Music, Intersong Music, Sony Music Entertainment, Arista Music, Arista Records, like the Arista Records, LaFace Records, Provident Label Group, Sony Music Entertainment, Volcano Entertainment III, Zamba Recordings, Sony ATV Music Publishing, and then about a dozen EMIs, EMI El Gallico Music, EMI Algae Music, EMI April, EMI Blackwood Music, Coldrum's EMI Music, EMI Consortium Music Publishing, doing business as EMI Full Keel, EMI Consortium Songs, doing business as EMI Longitude, EMI Entertainment, doing business as EMI Foray, EMI Gemixol, EMI Feist, EMI Miller, EMI Mills, EMI Unart or Unart, EMI U Catalog, Joe Beat Music, not EMI, Stone Agate Music, Screen Gems EMI, Stone Diamond Music, UMG Recordings, Capitol Records, Universal Music Corp, Universal Music MGB North America, Universal Music Publishing Inc., Universal Publishing AB, Universal Music Publishing Limited, Universal Music Publishing MGB Limited, Universal Music Z-Tunes LLC, and then Island Music, Polygram Publishing, and Songs of Universal versus Charter Communications. So I thought that was just everyone. So what do you think of Charter getting hit with that? Let us know in the comments below, and maybe you'll end up on next week's comment review. Thanks for watching. I am Leonard French, your favorite copyright attorney. That is our show. Thank you to our sponsors in the month of October. Remember, this is a show that was produced at the end of October, on October 31st, so that there will be a slight rollover. Supporters who support in November will get charged on November 1st, and will also roll over into the very first days, 1 or 2 days of December. So thank you to our October sponsor, channel sponsor, Joshua Davis from TandaPay. Thank you very much for for all of your support. Thank you to our October $50 plus supporters, Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin Hitov. And thank you to the $5 plus supporters who are scrolling on this screen in front of me, and all of you are on the LED panel behind me. I'm Leonard French, your favorite copyright attorney. I look forward to seeing you in the videos that drop. I will see you on Sunday for the 10 a.m. show at the US time. I love you all. Bye.